you will find these descriptive words of grounds for removal from office in removal of other office bearers from office under our constitution, like judges of superior courts. They'll be removed on similar grounds. And you'll see the Supreme Court has dealt with that in the case of Muya versus the tribunal appointed to investigate the conduct of Justice Martin Mati Muya, Judge of the High Court. In that matter, the Supreme Court now attempts to give us the meaning of the word gross. And you'll find that at paragraph 181 of that judgment of the Supreme Court. And it says, like what? Clearly, all the words used to describe gross express some extreme negative conduct. Not just negative conduct. It says extreme negative conduct. Then it proceeds to say a degree of misconduct of such a serious, outrageous, and flagrant nature that will warrant removal of a judge from office. That is how serious it ought to be. Those are the words of the Supreme Court. So, the Court of Appeal, I have already observed, sets that standard in the Martin Nyaga Wambora and 3 others. I'll just refer you to paragraphs 42 through 45 of that judgment. But there is something else that I want us to draw from the Martin Nyaga Wambora case. How to frame charges for an impeachment motion. Because the Court of Appeal also dealt with that question. And when you look at paragraph 44 of the Martin Nyaga Wambora decision, the 2014 Court of Appeal decision, that's one I have in mind. If you look at paragraph 44, you will see that the Court of Appeal draws similarities in drawing charges for an impeachment motion to drawing criminal trial charges for court. In fact, the court uses an example of how to draw a charge of robbery with violence in trying to explain how specific a charge for impeachment should be. I say this because in drawing criminal trial charges, there is a wrong in framing charges called multiplicity of charges, and I'll show you how that wrong applied in the trial of His Excellency Rigathi Gachagua. Then finally, for the High Court jurisprudence, I will refer you to the High Court decision in Honorable Mike Sonko Mbuvi, Gideon, and Okia Omtata versus the Clerk, Nairobi City County Assembly. These were 2 consolidated petitions. And I will draw your attention to paragraphs 257 through 259 of that judgment of the High Court. For ease of reference, I will refer you to the various aspects of the impeachment motion